Trump loses the Illinois National Guard case. So in the melee of information coming out, this full spectrum dominance and a distraction campaign where one news story is a distraction from the other news story, I missed an important case that the Supreme Court ruled on. Remember, what happened was that Donald Trump deployed the National Guard in Illinois. Illinois went to court saying that Donald Trump does not have the authority to deploy the National Guard in Illinois. The federal district court agreed and stopped the National Guard from being federalized and deployed. The Seventh Circuit Court of Appeals agreed with the lower court that you cannot deploy the Guard in the state of Illinois, may be able to federalize the Guard. What the Supreme Court asked was an interim question on whether or not to keep the deployment of the Guard stayed or allow the Guard to go into Illinois, into Chicago, while this case was ongoing on whether or not the Donald Trump is allowed to go into Illinois through the National Guard. The other issues in the case have to do with constitutional violations, and there's another case where plaintiffs come and sue DHS and NOAM, but that's not this case. This case is about statehood. It's about activating of the military and the National Guard to states. And the Supreme Court says that you cannot deploy the National Guard into the states right at this point because the president has not been able to show that 12406.3 permits the president to federalize the Guard in the exercise of inherent authority to protect federal personnel and property in Illinois. Now, that's the short of it. And there's also a very funny concurrence that I would like to talk about. But first, what I'm going to read to you is the meat of the ruling, okay? So the court said that we asked the two parties to address this issue, the meaning of the term regular forces in 12406.3. The government argued the term refers to civilian law enforcement officers, such as those employed by ICE or Federal Protection Service. Respondents, echoing the district court, maintain that the term refers to federal forces of the United States military. We conclude that the term federal forces in 12406 likely refers to the regular forces of the United States military. This interpretation means that to call the Guard into active federal service under 12406.3, the president must be unable, without the regular military, to execute the laws of the United States. Because the statute requires an assessment of the military's ability to execute the laws, it likely applies only where the military could legally execute the laws. Such circumstances are exceptional. Under the Posse Comitatus Act, the military is prohibited from executing the laws except in circumstances expressly authorized by the Constitution or an act of Congress. So before the president can federalize the Guard under 12406.3, he likely must have statutory or constitutional authority to execute the laws with the regular military and must be unable with those forces to perform that function. At this preliminary stage, the government has failed to identify a source of authority that would allow the military to execute the laws in Illinois. The president has not invoked a statute that provides an exception to the Posse Comitatus Act. Instead, he relies on inherent constitutional authority that, in the dissent, They talk about that. And so does Kavanaugh's concurrence about the executive branch's inherent policing authority. But that's not brought up in this case. Instead, he relies on constitutional authority that, according to the government, allows him to use military to protect federal personnel and property, with the assistance of 12406, mind you. But the government also claims, consistent with the longstanding view of the executive branch, that performing such protective functions does not constitute executing the laws within the meaning of the Posse Comitatus Act. If that is correct, it is hard to see how performing those functions would constitute executing the laws under 12406(3). So this whole idea of Donald Trump being unable to execute the laws, he has not shown that in this case. And the preconditions to allowing the military to come onto the streets would be an exception to the Posse Comitatus Act, which he has not invoked. Thus, at least at this posture, because it is an interim case, the government has not carried its burden to show that 12406(3) permits the president to federalize the Guard in the exercise of inherent authority to protect federal personnel and property in Illinois. Okay, that's the ruling. And the Kavanaugh concurrence, again, to me, it's hilarious. Kavanaugh, in the Perdomo case, made a concurrence about essentially how you could use one's race, one's ethnicity, what they speak, where they congregate to work, and what type of work they do as part of the reasonable suspicion analysis. Or at least that's how his concurrence was interpreted. And it went viral, and the idea of Kavanaugh stops being another name for racial profiling sort of went into the zeitgeist. Well, what happened was, in this case, Kavanaugh wrote a concurrence saying that on the current record, it does not appear the president has yet made the statutorily required determination that he's unable with the United States military, as distinct from federal civilian law enforcement officers, to ensure the execution of the federal law. So for him, it's a much narrower ruling. It would be a narrow ruling that the president has been unable to show that he was unable to use the U.S. military to execute the federal law. He wouldn't go further into regular forces and interpretation of unable to execute the laws of the United States and all of that. But what's important about the Kavanaugh concurrence is that just because he wanted to, he, in a footnote, wrote this: the state's opposition to deployment of the National Guard appears to stem from the state's underlying objections to the activities of federal immigration officers when they make immigration stops and arrests in Illinois. And that happened to be the same case in the Perdomo case. And so where he gave his Kavanaugh stop thing. Then he goes, the state and the government disagree about whether the immigration officers violated the Constitution in making certain immigration stops and arrests. The basic constitutional rules governing that dispute are long-standing and clear. So here he's clearing his name. The Fourth Amendment requires that immigration stops must be based on reasonable suspicion of illegal presence. Stops must be brief. Arrests must be based on probable cause. And officers must not employ excessive force. Moreover, the officers must not make interior immigration stops or arrests based on race or ethnicity. He very clearly says that here. This application does not require us to delve into the parties' underlying dispute and to determine whether any particular immigration encounter or series of encounters in Illinois has violated those basic constitutional principles. So he reasserts and in a way, he even like strengthens the Fourth Amendment's requirements, which has been eroded by the Terry line of cases, where reasonable suspicion comes into play, and reasserts that if you make an arrest that stems from a reasonable suspicion, you must get to probable cause of being illegally or undocumentedly being in the United States to be able to make an arrest. So you actually have to make a probable cause finding, which is a higher threshold than just a reasonable suspicion, where you specifically have been able to identify that this person, there's probable causes that this person is illegally in the United States or in the United States without proper documents. So I find it hilarious that Kavanaugh wanted to sort of clarify his earlier gaffe in the Perdomo case, and the coining of the term Kavanaugh stops, and here he wants to stop the Kavanaugh stops from being called Kavanaugh stops. I don't know if that's going to work, but thank you, Justice Kavanaugh, for reasserting the Fourth Amendment right against unreasonable searches and seizures. With that said, thank you for listening, everybody, and please remember to like, share, and subscribe, and I'll talk to you soon.